Yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning and welcome to the Court of Appeals sitting in Jackson.
Good morning, Your Honor.
We welcome you online. This matter will be heard as you can see online, but we'll conduct this hearing just as we would if we were in court. Although you're welcome to maintain your seats. You do not have to stand for this hearing. I'd like to introduce the court today, your panel. Judge McGee from Savannah, Judge Armstrong from Memphis, and I'm Judge Golden. Madam Clerk, do we have anything else we need to discuss before we call the first case?
No, sir.
All right, you may call the first case.
Perry Allen et al. Versus William B. Lee et al. Mr.
Fox, I believe.
Yes, Your Honor.
I understand you've reserved 3 minutes, so you may proceed.
Thank you very much, Your Honor.
You still need to identify yourself, though.
Yes, thank you. May it please the court, Andy Fox, on behalf of the appellants, Perry Allen and Roller Express Incorporated. Your Honors, Perry Allen and Roller Express Incorporated were told by the governor of Tennessee that they could not engage in commerce for over 2 months, could not execute their right to work or engage in a common occupation, not be able to live out their property interests, which were their properties. And this was all based upon a mere suspicion that their commerce may pose a risk to the community at large. Now, Mr. Allen and Roller Express were not convicted of any crime that interfered with, where the government could come in and interrupt their commerce. They had not been found to have violated any sanitary standard or other types of regulations. All they did, or all that happened, is the governor just came in and summarily and conclusively disposed of their business interests until such time as the governor decided to relent. Now, to my knowledge, the last time there was this kind of government interference with people's civil liberties and with their lives based upon a mere suspicion that they may pose a risk to the community at large was Korematsu. Now, I don't suggest to the court that the indignities suffered by Perry Allen and Roller Express were anything close to the scope of indignities suffered by the Japanese citizens subject to internment, but the rationale is the same. And the indignities suffered by Perry Allen and Roller Express were not trifling. They couldn't earn a living for 2 months just based upon a mere suspicion, an emergency, a mere suspicion, and then their civil liberties are suppressed, just like what happened in
Mr. Fox, I'd like you to address the state's argument about the fact that this matter is now moot.
Okay, thank you, Your Honor. Yes. Your Honor, this case in the as given by the factors appearing in both the Norma Faye Piles ranch case and the Hooker versus Haslam case, this case fulfills all the exceptions identified by those two cases. We have the voluntary cessation exception. The governor is the one who stopped the conduct that was raised, or the offensive conduct. But although my client raised the issue of the offensive conduct while it was being perpetrated. So we have the voluntary cessation. We have the collateral consequences exception because my client suffered financially. In addition, they suffered indignities to their constitutional rights. And that in and of itself is considered to be irreparable harm. So they suffer financial consequences and irreparable harm through constitutional encroachment. These executive orders, although 2 months was a significant period of time and caused damage, it's still not long enough for somebody to fully litigate a case with these kinds of issues. So we have an evading judicial review exception. And of course, we have the public interest exception. And if you look at the factors appearing in the Hooker v. Haslam case, all of these threshold factors exist. This is an issue of great public importance. Excuse me. The boundaries of power in an emergency situation and whether the legislature's overstepped its authority in delegating power to the governor, delegating things that even the legislature couldn't do if the legislature or the General Assembly legislated it. These are of great importance. The public needs to be apprised whether these actions taken by both branches of government are allowed. And we have it laying right here before us in this case. This case touches upon wide swaths of the public. Although not every Tennessee citizen was forced out of work, many, many people stand in the shoes of Perry Allen and Roller Express. The public, this issue is likely to arise in the future because now a baseline has been set that what turned out to be a very a non-existentially threatening disease, infection fatality rate of about 0.2%, can be the basis for an emergency that lasts a year, not 2 months, not 2 months to stop the spread or whatever, a year. In fact, we still have emergency orders going on. So yes, it's very likely that this will arise again. And then if you go to the additional balancing interest, we have, yes, that future government officials, public officials, and governors, public health officials will be assisted by a boundary being drawn by the courts as far as where this emergency power boundary exists. And as I stated, there's a likelihood that this kind of thing will occur again. Anytime that you have some type of disease that's other than just a little bit more than the common cold, the government can come in and declare emergency or declare that their emergency exists. Well, it's likely that this will happen again.
Is this like a common cold, Mr. Fox?
I'm sorry, Your Honor.
You said we could have another situation where something a little bit like a common cold would occur and the governor would exercise its power. Are you suggesting that this is like a common cold?
More than the common cold. The flu epidemics, for instance, the flu epidemic that occurred in the late 60s and the late 50s, that was more than the common cold. No, I didn't speak clearly, Your Honor. What I said was more than the common cold. I'm not suggesting that the government would try this with the common cold. And of course, the costs and difficulties of litigating this issue. As I pointed out in the declaration already, attorney's fees are $30,000 under my regular rate. And they actually are more than that, given my preparation for this. It's cost a huge amount of money to undertake these litigations. And the court now has this situation before it. The court should take action because the court needs to set a stake in the ground. I think not only with regard to this emergency situation, but with regard to the policy of notice pleading that the Supreme Court has been very clear about. This is a notice pleading state, not a plausibility pleading state. And what the trial court did was engage in a plausibility analysis by taking hearsay evidence from outside the four corners of the document and decide that the theories advocated by appellants are not adequate. That's a plausibility analysis. So I think the court needs to take this opportunity to reinforce this is a notice pleading state as declared by Gore versus Department of Corrections, West versus Schofield, and Webb versus Nashville Area Habitat for Humanity. Also,
Mr. Fox.
Yes.
Mr. Fox, what specific evidence do you allege that the court took into consideration? You say hearsay, but what specific evidence was taken into consideration that would not be proper and normally subject to judicial notice?
Well, all the medical journal evidence, that's not proper. You can't take judicial notice of medical journals. In fact, we know now that there was a medical journal that published an article related to COVID that was retracted, The Lancet. These are medical opinions, and there may be other medical opinions. That's how medical conclusions are determined. They, over a course of time, different professionals post their opinions about it. And they post, well, in this study, this is what happened. But this study over here, this is what happened. That's why it's hearsay. It's just opinions. And the court used that to determine, the severity of this disease and find that the claims just weren't warranted under basically a balancing test. The court engaged in balancing and said, well, this is an emergency, and due to this emergency, what the governor did was appropriate. And I want to point out, by the way, when the plaintiffs pleaded that these statutes and these executive orders were unconstitutional in paragraphs 25, 35, and 46 as applied to the appellants. Under the standards for motions to dismiss, that automatically, by definition, invokes a fact analysis that must take place. And the court should have found, based upon that allegation, that all the factual inferences going into that are in the favor of the plaintiff, right? It's by definition, as applied as a fact-based standard. Is the court suggesting that we ought to file a 200-page complaint listing all the facts of why an as-applied challenge should be in the favor of the plaintiff? No, this is notice pleading. So right there, when somebody says as applied, that means, okay, we have to deal with facts, and those facts should be, the inferences for those facts should be drawn in favor of the appellants or the plaintiffs. And I want to point out too that the appellants the appellees try to use Riggs versus Burstyn as a basis for allowing the adjudication of a case to take place at the complaint stage, which, in the Webb case, the court said it's ill-suited at that stage of the proceedings to do that, to adjudicate the case at that level. But Riggs versus Burstyn has been implicitly overruled by Gore versus Tennessee Department of Corrections and Webb versus National Area Habitat for Humanity, and really explicitly overruled by West versus Schofield, because West versus Schofield said that factual inferences must be drawn in favor of the plaintiffs. The Riggs versus Burstyn and the Dobbs versus Gunther case said they don't have to be drawn in favor of the plaintiffs. So that's been explicitly overruled by the West versus Schofield case. And that is, of course, in line with the policy of notice pleading. So that case is no longer valid precedent. The valid precedent is the 2003 case of Gore versus the Tennessee Department of Corrections, the Webb versus Nashville Area Habitat for Humanity, and the West versus Schofield case. Those are the valid precedents for conducting an analysis of a motion to dismiss. And what the court should have done is it should have said, first, is there a recognized cause of action? Okay, like if plaintiffs had suggested a constitutional tort case, well, that's not a recognized cause of action in Tennessee, and the court would have been justified in dismissing it. Then the court should have, after determining that, yes, this is a recognized cause of action, it's a DEC action, we have a statute authorizing this, then the court should have said, okay, well, have all the elements been pleaded? There was a case cited by the appellees, the Singer versus Highway 46 props versus Dixon title case, where the court found they left out an element was necessary. That didn't happen in this case. Plaintiffs pleaded all the necessary elements to have a viable declaratory judgment case in paragraphs 2 through 3, real interest, 11 through 16 in 2027, real controversy, and 17 and 18, the defendants oppose the declaration sought. Thank you.
Thank you, Mr. Fox. You'll have your rebuttal time. Now we'll hear from the appellee.
Thank you, Your Honor. Good morning. Janet Kleinfelter with the Attorney General's Office, and I'm here on behalf of Governor Lee. And Your Honor, respectfully, the appellant in this case is asking this court to issue an advisory opinion because this case and the relief that it no longer presents a live justiciable controversy. If you look at the complaint and the relief that was requested by the plaintiffs in their complaint, they asked for 4 things. They asked for a declaration that Executive Order number 30 is unenforceable. Executive Order number 30 by its own terms has expired. Second, they asked for a declaration that Tennessee Code Annotated 582107 is facially unconstitutional and as applied to plaintiffs and their customers. Third, they asked for a declaration that 582105 cannot be construed to allow the governor to declare martial law. And then they asked for an injunction restraining the issuance of any further executive orders that affect plaintiffs' liberties to travel, operate their businesses, or patronize other businesses currently prohibited from operating, or plaintiffs' customers' liberties to travel and patronize plaintiffs' businesses. And this is all focused upon executive orders that were issued by the governor back in March and April of 2020, all of which expired and no longer in existence, are no longer enforceable, and expired. Actually, Your Honor, they expired before the trial court had actually issued its memorandum opinion granting the state's motion to dismiss, but after the motion to dismiss had been briefed and fully argued by the parties in front of the trial court. And under those circumstances, we simply don't have a justiciable controversy. And respectfully, I have to disagree with counsel that either the exceptions that the courts have recognized to the mootness doctrine are applicable here. The first exception is that it's capable of repetition, but evading review if not addressed by the courts. But the Supreme Court has made it very clear that for that exception to apply, there has to be a reasonable expectation that the acts provoking the litigation will reoccur, that judicial remedies may not be effective if the acts do reoccur, and that the same party will be prejudiced. None of those elements are present here, Your Honor. There is no reasonable expectation that we will have another pandemic. If Your Honors, I'm sure you're aware, the last time there was a pandemic was over 100 years ago with the Spanish flu that took place in the early 1900s. It would be entirely speculative to say that we are going to have another pandemic that would result in the same acts, the issuance, the declaration of a state of emergency by the governor, and the issuance of the executive orders that plaintiff is challenging here. So it would be purely speculation. Second, there's no indication that the judicial remedies that plaintiff has sought in this case would not be available and be effective, particularly if they were sought earlier. Your Honor, if you look at the record and the time frame here, the governor's executive orders were issued in mid to late March, very early April, and yet plaintiff did not even file their lawsuit until the end of April. So we don't have a situation where the judicial remedies, if these acts were to reoccur, would not be effective, nor is there any evidence in the record that the same party, the plaintiff, Mr. Allen, and Roller Express, Inc., would be prejudiced if these acts were to reoccur. So the capable of repetition but evading review exception simply isn't applicable here. We have the same problem with what is considered to be the public interest exception, and that is one where the courts have said, in particular the Supreme Court has said, that for that exception to apply, the issue must be, quote, one of great public importance, as where it involves a determination of public rights or interests under conditions which may be repeated at any time. And so for the same reason that we don't have the capable of repetition exception applicable, we also don't have the great public interest exception applicable, because we don't have a situation where these conditions are capable of being repeated at any time. We simply don't have any evidence indication that there's going to be another worldwide pandemic that is going to result in what has happened over the past year with respect to COVID-19. And when you look at the factors that the Supreme Court identified in the Norma Faye Powell's case, the factors really don't counsel in favor of finding that the exception applies. As I indicated, it should only be invoked with regard to issues of great importance to the public and the administration of justice. It should not be invoked in cases affecting only private rights and claims personal to the parties, which is what we have here. It is purely what the plaintiff is asking for. It should not be invoked if the issue is unlikely to arise in the future. And again, it's entirely speculative that this issue is ever going to arise again in the future. And it shouldn't be invoked if the record is inadequate or if the issue has not been effectively addressed in the earlier proceedings. However, we think the issue has been appropriately addressed in the proceedings that have already taken place. And so we would submit, Your Honor, that the great public interest exception simply isn't applicable here because we don't have similar circumstances. There's no substantial probability that the conduct that gave rise to the dispute here is going to reoccur. It is based upon the specific facts and circumstances concerning this pandemic and what was happening at the time that the governor issued his executive orders. And so respectfully, it actually would not provide any determination by this court would not provide assistance to public officials in the future, because again, it is limited to the specific facts and circumstances that are involved here. So for all those reasons, we respectfully submit that plaintiff's case is moot and that it should be dismissed for lack of subject matter jurisdiction. With respect to the other two issues that plaintiff has addressed, one is this concept that the trial court erred in granting the state's Rule 12b-6 motion to dismiss because this was a declaratory judgment action. Respectfully, Your Honor, declaratory judgment action is a vehicle for allowing a party to assert certain substantive claims for relief in the court. But the party, that plaintiff, still has to demonstrate that their underlying claims are legally sufficient. And that is absolutely the purpose of a Rule 12b-6 motion, because it challenges the legal sufficiency of the claim, of the complaint, not the strength of the plaintiff's proof or evidence. And that is exactly what we had the trial court did here. The trial court looked at the allegations in the complaint, the allegations that the governor's executive orders and the statute under which they were issued, the allegations that they were unconstitutional in violation of different provisions of the Constitution, that they imposed martial law and violated due process. Those allegations are all legal conclusions. They are not factual allegations. And so the trial court did absolutely what it was supposed to do, took all the factual allegations as true, but looked at the legal sufficiency of the claims that were asserted and found that there wasn't legal sufficiency there. And Your Honor, particularly when the plaintiff is asking for an interpretation of the Constitution and an interpretation of a statute, the Supreme Court has made it very clear that those are questions of law. So it was entirely appropriate for the trial court to rule on the motion to dismiss and to grant the motion to dismiss. And then finally, with respect to the matters that the plaintiff asserts were outside the four corners of complaint that the trial court considered hearsay, again, that is not borne out by the trial court's decision. The trial court made it very clear that while the matters that we had cited were appropriate to be considered because they were either matters of official government records, and therefore public records, or they were matters of which the court could take judicial notice. The court went on to note and specifically state in its opinion that those facts, the facts that plaintiff is alleging the trial court shouldn't have considered, the trial court, quote, said, the facts do not purport to counter or even address the factual allegations in plaintiff's complaint. And therefore, the court, they did not interfere in any way with the trial court's accepting plaintiff's factual allegations to be true and construing them in the light most favorable to the plaintiffs. Essentially, Your Honor, the facts that plaintiff has complained about didn't factor into the trial court's ruling at all, because again, the trial court was ruling on the legal sufficiency of the claims that plaintiff had made and didn't address the factual allegations whatsoever, other to note that there was deficiency in the factual allegations with respect to plaintiff's allegations that the governor's executive orders as applied to plaintiffs, there were no factual allegations demonstrating that the governor's executive orders exceeded the scope of the authority that had been delegated to him in 58-2107. We have otherwise addressed the merits of the trial court's ruling on the legal sufficiency of his claims. And unless the court has any questions with respect to that, we would respectfully ask that the decision of the trial court be affirmed.
I don't hear any questions. We'll now go to Mr. Fox for his rebuttal. Thank you, ma'am.
Thank you, Your Honor. First, I want to address Judge McGee's question because there were a couple other matters of evidence that we took exception to. One was, of course, the governor's findings. I know of no rule or law that says a governor's findings issued in this situation can serve as substantive evidence. These aren't legislative findings. Number two, there were other government statistics or government government suggestions, government.
Is that were the governor's findings part of a public record?
They were, but that doesn't mean that, well, no, actually, I take that back. Your Honor, public records aren't automatically admissible. There are foundation requirements that are involved in accepting a public record as evidentiarily admissible. What was the problem here with that? What was the problem with the governor's records being considered a public record? Well, he relied upon hearsay. He himself relied upon. It wasn't conducted as a matter of like a business record exception, where it's just some government agent doing their due diligence as part of their job, collecting statistics. He in turn relied upon hearsay evidence, hearsay. So it was really like a double hearsay situation in a sense. Those public foundation things were not even offered. The appellees didn't even offer a public foundation exception. Now, okay, here's the underlying stat or cause of action. 29-14-103. Any person interested under a statute may have determined any question of construction or validity. See, Tennessee doesn't have a Section 1983 claim. So yes, a declaratory judgment action often does serve as a vehicle, but in this case, it's just a straight up statutorily authorized cause of action. That's your cause of action. That's what the plaintiffs pleaded, a proper cause of action under a DEC action. No expectation. If you talk to people in December of 2019, they'd say, we haven't had a pandemic in a long time. Of course, I disagree with counsel that we had the Hong Kong flu, I believe, in 1968, and we had the Asian flu in 1958. So it hasn't been 100 years. They happen. And like I said, in December 2019, I think at that time, we were told that this thing couldn't even transmit over to humans. So you never know when it's going to come back. Yes, it can happen. And if you look at the length of all these executive orders, which they're all now part of the record, they're all like 2 months long. And then Governor Lee kept extending them. So it is too short of a duration to really accomplish an adequate examination by the courts. So again, this case should be, we have the ability to test the boundaries of this emergency power statute right now in front of us. All of the exceptions apply. Thank you. Please reverse this case.
Thank you. Council will take your case under advisement and will issue an opinion as soon as possible. Thank you very much for your argument today.
Thank you, Your Honors.
This Honorable Court of Appeals is in recess until 10 o'clock.
Move us. Kevin? You there?
Yes. You can go ahead,
The
stop the stream.
Honorable Court of Appeals is in recess until 10 o'clock.